Okay, do we have the little recording button? We're all good? Yes? Cool. Okay, so welcome everyone to week 8 of Contract A. And week 8 of Contract A is a rather interesting mishmash of stuff. Wow, what a tutorial we have in store tonight. Have you started looking at the material? Can I just have a little indication? I'll just open up my chat box. Can I just have a little indication of how many peeps have had a little look at the material? Just a Y or an N would be fine. Oh, cool. Great. So we have some peeps that are up with the material. That is very, very good. What I will do is, without further ado, we'll jump straight into the tutorial. It's a fairly massive tutorial tonight, and normally we spend a fair bit of time just going through, you know, the readings for that week and just doing some general revision. But what I'd like to do tonight is kind of do the revision in amongst the actual questions posed by the tutorial itself, so that we don't run short on time. So what I will do is I will share my little document here. Now, can everyone see that? Cool. Okay. So we have Michael's going to Belgium on this lovely holiday to eat chocolate. That's my kind of holiday. While away, he's asked this person called Libby to house sit. She thinks it's rather good. Excuse me. Because it has these mod cons being Foxtel and an espresso machine. Okay, it seems like they're friends because they trust each other. But to be on the safe side, they conclude a written agreement about the house sitting. Here, things like this, you know, be very mindful when you're in an exam to watch out for things like that, because so many times in exams, and take it as read, peeps, that from now on in, you know, whenever I can give you, you know, tips about exam technique, I will be, given that, as I've mentioned, you know, we're kind of on the slow descent into exam fun. This is a very clear limitation on anything that you might be required to do. Now, a properly written exam question would have something like that in the actual body of the question down below. Anyway, it's not here, but I'm just telling you this because I find that so many student errors in exams are caused by inadequate reading of the problem. Okay, I'm just saying, I don't, you know, the way that this question is worded is okay, but, you know, just do beware for, you know, questions that are written like that might leave other parts of it elsewhere in the actual problem. Okay, so we've got these, we don't have to worry about formation. And that means, it doesn't mean, we don't have to worry about whether or not Libby and Michael were related, not related, whether they, you know, had intention, whether they had capacity, or any of that other stuff. All that we're worried about tonight really is construction. Okay, so we have this clause where she agrees to water the plants every day and to be liable for any plants that die while she's house sitting. Also, she agrees to ensure the mailbox is cleared daily. Also, and I'm assuming that she's put this in, okay, because it says Michael agreed, a clause in which Michael agreed that Libby would not be liable for any damage caused to the house because of electrical faults. And there was another clause under which either party could terminate by email with 24 hours notice. Okay, they are the salient contract terms. And get used to this kind of question. I didn't write this question, but I don't mind it. And it's something similar to how I write my Contract B questions, my big Contract B questions for the end of term exam, in that I will normally include some contract terms there for you to actually look at, and then I'll get you to advise on the contract terms. So for those that are going to do Contract B, heads up, I won't be doing Contract B next term. I'll be doing it in T2 of 2019. Okay, so Michael goes away, Libby moves in, she waters the plants every day, but one of them only required watering weekly, so it died. She emailed him to tell him. She says, I don't want to be responsible because, you know, you asked me to water the thing every day. He says, and this is where we start to see the parties' relationship kind of taking a nosedive, she agreed to be liable if any plants died, so please replace the plant. She then gets ticked off, and she indeed clears the mailbox daily as required, but she just dumps all the mail in the bin. So he misses out on a job as a result of that. Then she decides to invite a dozen girls over for a girls' night. They get this paid entertainer over. He plugs in a stereo, smoke machine and disco lights, and all of that overloaded the system and caused a fire, burnt the house down. And she immediately rings him and terminates because the house was no longer habitable. I love the artificiality of these law school problems, but they're kind of fun. Okay, so Michael obviously wasn't amused. He demands that she pays the excess on the insurance claims, total of $8,500, including both the house insurance and contents. She points to the contract and says to him she's not responsible for damage caused by electrical faults. She refuses to pay. He's come to us for advice. Okay, so for our prep work, we need to consider a number of different things. Okay, whether she's obliged to replace the plant, whether she's breached the contract by putting the mail in the bin, whether her termination was effective, and whether she can rely on the exclusion clause. Okay, so moving to the first question. Does she have to replace the plant? Okay, so the relevant clause, she's got to water the plants every day, and she agrees to be liable for any plants which die whilst she is house sitting. Okay, what is our first port of call here? What is our first rule of construction that we're going to remind ourselves of before we go and unpack all of this? The first rule of construction.
Is it unambiguous? Like, is there any ambiguity in the words?
Yes, and flip side of that is if there's no ambiguity.
Yeah. So if there's no ambiguity, then you just read it on its merits or on the face of the words.
Yes, exactly. So we have all of that good stuff that Wilmot tells us in 9.2.1. These are the main points for the ordinary garden variety run-of-the-mill construction exercise, okay? The meaning is a question of fact, depending on the words. The legal effect is a question of law. The way that you go about working out the meaning of words is objective. So your friend, as per usual, is the good old reasonable third party. Okay, the document has to be construed as a whole, and the court will normally try to give effect to the contract. That was something that we had a little look at in our excursion into certainty, wasn't it? The Hillis and Arcos case in relation to the sale of softwood timber. The court doesn't like being the destroyer of bargains. But you just have to look at the clear and ordinary terms here. Okay, bit of a problem, and this is one reason why I don't, generally speaking, like to have a, and this is just a practical point in drafting. Can you see that there are two separate obligations here? One, water the plants every day. Two, liable for plants that die. But you shove them together and there is the potential to cause a bit of uncertainty, isn't there? Because what's happened? What's Libby going to try and argue, or what has Libby argued?
That the plants dying liability is only when she hasn't ordered them.
Yeah, she's saying, I did what you wanted. I watered the plants every day. So this liability here should only apply to when I haven't actually, lived up to my first obligation there. Do you see what I mean? When you're drafting, it's good to have things working in a very crystal clear fashion, and I don't like conjoining obligations usually when I'm drafting like that. Okay, it gives the other party an option to try and shoot for some ambiguity there. Okay, so we have these two separate obligations that are required. The difficulty is that Libby's, it may have been subjectively intended that she would only be liable for plants that die if she hadn't met that first obligation. But what do you think the clause actually, on its plain reading, would say to you? Water the plants every day, and you're liable for any plants that die while you're there. What would a reasonable third party say? What do you think?
I think for me it's kind of a bit tricky when you look at it, and this is what the textbook talks about, how and all the case law, where it talks about you're supposed to read the whole, construe the whole document and not just cherry pick provisions. Like, I think you'd have to see how it sat in amongst all the other provisions to definitively say, because if it looked like all of the other provisions have train smashed, disparate clauses in together, and it was just a case of sort of poor drafting, where, as you say, there's two obligations in the one sentence just because, for brevity's sake or something, in the language. But if it was the case where that was an oddity, where there was two obligations train smash together. I think, and the rest were all just sort of single obligation per clause. I think then you'd be able to mount a case and say what should be read together. You know what I mean? So like that context, which obviously we don't get in the question, would go a long way to helping.
Yeah, have a look to the other terms of the agreement. Sure, absolutely. What does anyone else have a different view? If you just read it of itself, she agrees to water the plants every day and to be liable for any plants die while house sitting. What do you think? Go on, Tammy Lee. Wade in.
When I was looking at it, I said she was liable because I was reading it as it was worded. So whether it was fair or not, I sort of just said, well, this is what it says, right or wrong. That's how I looked at it, but I can see the other side of it. But I was looking at it in that she was liable because that's the way the contract was worded, and it's not looking at what they should have said or what they thought they were saying. It was about what they did say, maybe.
That is exactly how I approached it also. But what I do like here is this nice little argument that Damien has introduced, because it does throw up a very practical point about contract drafting. And this is partly why I actually want to get an elective. I know that no one's going to take it, but I want to get an elective going, which actually teaches you folks practical drafting skills like this, because it's all very well and good to know all of these theoretical principles, but having to actually sit down, if I gave you a task of here's the brief, go away and write me up a contract, it's a very different exercise. And I'm not going to say much more difficult, but a difficult in a different way exercise. And so that's why I like the point that Damien's raised, because it is a very practical drafting point. You can unnecessarily introduce uncertainty and ambiguity by smushing different obligations together. But in this case, it just says she's got to water the plants every day and she's going to be liable for all the plants that die. Unfortunately for her, I think a third party would just say she's copped to the fact that if any die, she's going to be responsible. There's nothing on the plain words that would limit that latter phrase to only plants that didn't require watering every day. I think it would be a bit of an uphill battle. But nevertheless, there is a scope for the thing to be argued. All right, so if this ever got to court, would a court allow, on Damien's nice little argument, extrinsic evidence to be led to show that the parties actually did intend subjectively that she would only be liable for plants that were watered incorrectly? Would the parole evidence rule apply?
So I think, for me, I think that the parole evidence rule would apply in so much that you couldn't lead it as direct evidence to like point at a statement and say, oh, this is what that person intended, as in their subjective intention. But I think you'd be able to, I think the court would be able to consider it as part of the matrix of circumstances surrounding, because you'd have to obviously get the court to agree that there is ambiguity, as in you can't just, there is an argument, and then if they agreed to that, then that opens up the possibility of them, because once there is ambiguity, they're allowed to look at the surrounding circumstances, and then you could point at stuff like statements like that. And so it's an indirect way of getting it in, not leading with the evidence, but getting them to consider it.
Yep.
The context.
So I'll just dump in my other document here. And we can go through, well, I'll dump in some of it and I'll make you work for you. I'll make you work for your money. Son of a tired and pesky lecturer. Okay. I'm not sure why it's continuing to number these, but anyway. Okay. If it got to court, the parole evidence rule would likely exclude Libby. Now, starting at the very beginning, remember when you're doing an IRAC, you need to make sure that you do things tediously, step by step. Okay, so if you were doing this part in an IRAC, you would start at the very beginning. The parole evidence rule would be the first thing that would stand in her way. So, Michael would argue, because remember Michael's our client, Michael would argue the contract was intended to be a complete record of the contract, okay, because that is when the parole evidence rule will cut in to stop that extrinsic evidence, okay. So he would be arguing there's no ambiguity here that would allow for evidence of the factual matrix. So where we have things like contracts being reduced to writing, intended as a complete or final record, your parole evidence rule cuts in. So you've got a citation of a case there. That's the kind of way that I would like to see you stepping through things from the very beginning in an IRAC in your end of term, okay? So extrinsic evidence would not be admissible. And then I've just gone through, I wouldn't expect you to do this in an exam scenario, but in CADELPHA, remember the true rule, as Damien said, is that you've got to have ambiguity first if you want to try and slip in some extrinsic evidence there, if you want to slip in some evidence as to the factual matrix, okay? Gibbs in ABC and APRA said if the words are unambiguous, you have to just give effect to them, notwithstanding that the result may be capricious or unreasonable, okay? And even if you think the parties may have intended something different. That's what Michael, your client, would need to be arguing, okay? Then if you were, let's just, because we're the curious law students that we are, you're not really at this time of night, I know, but no one is, but we'll pretend. There are many exceptions. Let's quickly go through the exceptions to the parole evidence rule in a nice handy little compendium bullet list so that we can look at them later if we need to, okay? What are, can you yell out some of them for me? Just yell them out randomly and we'll see if we can collect them all together.
If the contract's not started yet, so if the written contract's not in force.
If there is some evidence of suspension of operation, yes. And the case for that is, dang, I knew she was going to ask me that. Pym and Campbell, that's the engineer that they couldn't find to sign off on that document that said the contract wouldn't start until you had the sign off of the two engineers.
Yeah.
Yes. where else? Now I'm thinking, so we've said that the parole evidence rule only applies where there is a written contract. But what if it's not just written? What's the other exception that applies there? If it's partly written and, yeah, I lip read you, Tammy. Partly written and partly oral. That's the thing. What about if there are circumstances that show the contract might actually be invalid, like misrepresentation, mistake, undue influence, incapacity? There's a problem with incapacity. All of these defects, if there's defects that you need to argue, the court will let that evidence in. Okay? And then obviously ambiguity as well. So I'll just dump these in now that I've made you work hard. Okay. So suspension, invalidity, ambiguity, they are your main ones. If we take the most favourable construction of that that clause, it seems to me, I think at least, arguably clear on its face, and I think that if the court accepted that in Michael's favour, and bearing in mind Michael's your client, then I think Libby would probably be liable. Okay? Alrighty. However, oh, wow. So however though, if I did come across Damien's nice little ambiguity argument, I certainly would not mark that wrong. Okay? And it's kind of like the assignment. You know, it all comes down to the soundness of the arguments that you make a lot of the time. So if Libby was your client, you certainly would be trying to argue ambiguity there. Okay, so we all happy with that bit? Yep. Okay, so did Libby breach the contract by putting mail in the wheelie bin? Sorry, I just love this. Okay, so Libby cleared the mailbox daily. She threw this job offer in the bin. He missed out on the job. Question: did she breach the contract by putting the mail in the wheelie bin? Putting aside for one moment the fact that tampering with mail is a federal offence anyway. We'll just ignore that whole issue. Okay. Does the clause have a clear meaning? I'll go back to the same approach that I used in the last question. Does the clause have a clear meaning? To ensure, now, does Michael want Libby to be in breach here or not in breach? What's happened to him? He's missed out on a job, right? So he's pretty ticked about that. If he can show she's breached, he might be able to get some kind of damages, right? So your client's view is he would like to be able to prove a breach. Obviously, we have to be even-handed here. So if you can't prove a breach, you need to be able to tell your client that. But let's give it a good old crack. Is there a clear meaning here? Oh. Obviously, Libby would say she did clear the mailbox and that the parole evidence rule would exclude evidence to the contrary. So he would be trying to argue, well, ambiguity. Well, a number of different things. Actually, I'll just do a little jump here. So Wow. Why does it always start? There we go. Michael would want to introduce a meaning into the contract that clearing the mailbox requires her to take the mail out of the mailbox and leave it for him to pick up later, wouldn't he? Okay, so how can we get around, and this is where we start to go through our parole evidence rule again. There are a number of different ways to attack the parole evidence rule here and try and say that it should not be applied, and that evidence of the factual matrix or circumstances surrounding the contract should be admissible. Obviously, the first one that we had a look at up here, oh, where are we? I should put that in. Okay, so obviously Michael can't really argue that the contract in this sense was partly oral, partly written, because if he's just finished arguing above that the contract was a complete record of the agreement, and that the parole evidence rule should stop her, Libby, from introducing surrounding circumstances in relation to the plant dying, he now can't go ahead and say, oh, actually, it was partly oral, partly written. Do you see what I mean? And I find this problem a lot with students' answers to problem questions, often in an exam where you're rushed. You need to be mindful how the bulk of your advice hangs together. So if you've just finished in question 1 saying that the parole evidence should apply because this is a complete written record of our agreement, you then in the next question can't say, oh, hang on, it's partly written, partly oral. Do you know what I mean? You have to be aware of the old internal consistency issue. All right? So you would find that exception hard to use. But what about the old ambiguity issue? Would you argue that there was some ambiguity here? The clause is that she agrees to ensure the mailbox is cleared daily. She's supposed to ensure the mailbox is cleared daily.
I had a stab at this and said that it wasn't, there was no ambiguity, but that was based on, like, so the court would first look at it, you know, from put themselves in the shoes of the party, and I just looked at it that it's a contract for house sitting, and a reasonable person in a house sitting contract would there wouldn't be ambiguity in the words clearing a mailbox. But
and what would you suggest that clearing a mailbox?
Well, like, so yeah, so in the from the perspective of someone house sitting, that would be expected, that clearing the mailbox would be not letting it fill up, and then obviously you just do what you normally do with mail, which is not throw it straight in the bin.
Yes. The difficulty is that plain words again, they only address half the obligation, really, don't they? To ensure the mailbox is cleared, that is emptied. And she's done that.
Yeah, so you're saying that ambiguity is more, yeah, like it's more of a, as I think someone said in the chat, that it's more about lack of completeness.
Yes, it's kind of half the obligation, really, isn't it? Everyone knows what it means in a reasonable person's sense, but when you're looking at these words, it just covers the conduct that relates to actually taking the mail out of the mailbox. It doesn't speak to the issue of what's to happen to that afterwards, does it? It only requires her to take the mail out of the mailbox. So I think you could argue. Did anyone make an argument to the contrary to Damien? Did anyone think that there was an argument of ambiguity here?
I wanted there to be. Does that mean anything? I wanted there to be because I wanted it, you know, because it's out, like, to me, it's outside that four corners. It's not what someone would expect you to do when they put that in the contract. So she's gone outside of what an ordinary person would expect to happen within that. But again, we've got the plain words thing.
And this is where, you know, we've all got the vibe, you know. We know what should happen. And what we have to try and do is nut out a legally sound way of putting an argument together so that our gut feel aligns with the vibe and the legal authority, okay? So I would say there is some ambiguity in the term clearing a mailbox, because clearing a mailbox doesn't just mean emptying it. It means collecting it safely for a person to pick up later. And there's that nice little quote from ABC. And if we have a look at the quote, I think it might help us. It's right law, the primary duty of a court is to endeavour to discover the intention of the parties from the words of the instrument in which the contract's embodied. Of course, the whole instrument has to be considered. That's what Damien said earlier. Since the meaning of any one part might be revealed by other parts, the words of every clause have to, if possible, render them all harmonious together. If the words are unambiguous, the court must give effect to them, notwithstanding it might be guessed or suspected the parties intended something different. That's the bit that we used in Michael's aid for the previous question. And then the court went on to say the court has no power to remake a contract if it's inconvenient or unjust. On the other hand, if the language is open to two constructions, that will be preferred, which will avoid consequences that appear to be capricious, unreasonable, inconvenient, or unjust. So I guess you would say the ambiguity is, what is the purpose of the clause? To clear the mailbox in order that further mail can be received, because you need to read mail, don't you? So the whole purpose behind this clause is to ensure that our client was able to read his mail, all of the mail, from any source that happened to arrive in his letterbox during the course of his holiday. So he's put this clause in there. He obviously wants the mailbox to be free for receipt of further mail that he can read later. That's what he's put in there. And so I would argue that if you read that clause as allowing her simply to dispose of the mail, it's going to result in a consequence that is unreasonable, inconvenient and unjust. In fact, he's lost a job because of it. That would be my argument. I don't think it would win by any stretch of the imagination. But that's the kind of argument I think you would probably need to construct. Okay? As I said before, so if Libby's contended meaning was adopted, it would lead to an unreasonable or unjust consequence. I think his problem, and I don't think you can get around it, the words are unambiguous. It just said the mailbox had to be cleared, and she cleared it. Okay? The real problem was what she did with it after, and that's not covered by the clause. So the question was this clause breached? Technically, I don't think it was. Okay, she did clear the mailbox. All right, so on that tactic, I think she would have a good case to argue that there was no breach. Okay, that is if they were stuck with the plain meaning of the words and the parole evidence rule stopped Michael from leading any extrinsic evidence to show that the clause meant something else. Okay? That's just the first cab off the rank. I think there are a number of different other arguments that you could probably mount here, some of which may have occurred to you, some of which may not have occurred to you. Some of them occurred to me only as I was tapping out this stuff. If the parole evidence rule can't be avoided, submit that Michael's contended meaning was known by both parties and is a notorious fact. Okay, we have this nice little comment by Mr. Justice Mason in Cadelpha, where he says, generally speaking, facts existing when the contract was made won't be receivable, obviously because of the parole evidence rule, as an aid to construction, unless they were known to both parties. Although if the facts are notorious, knowledge of them will be presumed. So the parole evidence will cut in to stop everything else from any other extrinsic evidence, except if both the parties knew this fact and or it was notorious. Okay, so I probably would try something on here. I would say maybe the meaning of clearing the mailbox was known by both him and Libby to mean not just clearing it and throwing it away, but clearing it and keeping it safe for him to read later. I would also argue that it was known generally. It's just this is the thing that lines up with our gut feeling, isn't it? It's just a generally known thing. If you say, you know, can you please clear my mailbox for me while I'm away? It doesn't mean take the mail out and throw it away, does it? It's a notoriously known fact that if you ask someone to do something like that, the whole point is so that you get to read the mail later. Yeah? So that's what I probably would also throw into the mix. Let me further blow your mind, because I think that there are a few other little arguments that you could try on here if you're being nifty about it. Okay. There we go. Rectification. Yeah. Rectification is one of our potential holes in the parole evidence rule. Okay, so what is the whole notion of rectification about? Did you pick up on this when you were ploughing through the multitude of pages? I think there's about 150 pages, isn't there? So rectification occurs, and we touch on the issue of rectification in contract B also. So we kind of revisit it. We kind of come full circle a bit in contract B. So the following requirements have to be met. The parties have reached a complete written agreement, tick. The document contained an error or omission. What would we be arguing was our omission? The clause here was ensure the mailbox is cleared daily, and then she's dumped it in the bin. So one, parties reached an agreement. Omission, that Libby was to keep the cleared mail safe for Michael's later collection. Clear and convincing proof. Well, on that score, I think, can anybody mount an argument? How would you prove that the parties didn't intend that she could satisfy that obligation by throwing the mail away?
Why would he ask her to clear it at all then if he wasn't going to read it or wasn't interested in what was in the mail? If he was happy for it to be thrown away, he could have left it in the mailbox.
Yes, yes, exactly. The clear and convincing proof, I think, would be the concept of clearing the mail itself. The object is, 1, keep the letterbox clear so you can get more mail, and 2, either opening and reading the mail that had been cleared, or saving it for collection and later opening and reading. There's no point in clearing the mailbox if you're just going to throw it all away. Yes? So I think that there's, it's capable of clear expression. Well, I don't think that there would be a problem there. And there's no third-party intervention here. And by third-party intervention, I simply mean the circumstance where, for example, often when parties try and argue rectification of a contract, it may be that one or other of the parties has sold their interests in the contract to another party. Now, if that's happened and you've got this third party now in the mix, you can't go and ask for things like rectification. And we'll talk about third-party intervention in Contract B in much more detail. So don't worry about it too much here. But I think that you can make a reasonable argument there, don't you? I think that that's, not too shabby. So if that was the case, and the court accepted that the parole evidence should not apply because the contract needed rectification, then if the court actually did grant the rectification, she would have breached that rectified term. I think there's one other really nice argument that you could make here. And that relates to the stuff that we're going to look at next week in relation to implied terms. And again, you're trying to sweep in something that's not there, aren't you? Whether it's by way of rectification or whether it's by way of implied term, you're trying to get something into the contract that would show that she's breached it, that kind of lines up with your gut feel about, you know, how Michael should come out of this. What I will simply do here, because like I said, we're going to go through implied terms in much more detail next week. But Michael could simply argue that here, implied terms, leading evidence to establish implied terms is another exception to the parole evidence rule. So he could say the obligation to clear the mailbox daily on its face didn't really work because it was incomplete. So it needs something else implied in order to make that clause commonsensical, okay? You've got to have these 5 tests from BP Refinery and Hastings Shire Council. So the term has to be reasonable and equitable. I don't think we'd have a problem there. Necessary for business efficacy, we'll talk about that next week. So obvious it goes without saying. I think that's also satisfied here. Capable of clear expression, doesn't contradict any other expressed term. I think you could probably mount decent arguments in relation to all of those. Okay. Next one. Anyone have any comments or queries there? It's interesting how this stuff all plays out, isn't it? Because you read it on the page and you don't think of exactly what we do here, which is kind of you line up all of the exceptions to the parole evidence rule and you kind of almost try and tick them off one by one to see if you can shoot down the parole evidence rule and get your evidence in to get your client the result that they want, don't you? It's a different exercise, and this is why I say it's super useful to go through, as I know a number of you do each week because you send me your IRACs, and actually try and work out this stuff and apply it like we're doing it tonight, because otherwise the knowledge just kind of floats around in your head. It doesn't really get cemented down. It's really doing stuff like this that knocks the concepts into your brain. Is the termination effective? Is the termination effective? I think we can deal with this pretty quickly. The clause is either party can terminate the agreement by email with 24 hours notice. All of that conduct occurred, the fire resulted. Unfortunately, these items overloaded the system, caused a fire. She immediately notified Michael and terminated the contract. Now, I think you'll find in the actual facts, it doesn't say how she immediately notified him. I thought it said that she did it by phone. It doesn't say that she did it by phone. It just says she immediately notified Michael and terminated the contract. What was your gut thought on this one here? Did you have any thoughts?
I think I just assumed immediately meant that there was no 24-hour notice, because she's not going to be there 24 hours if she can't live in the house. So that's what I was thinking.
Yeah. So I thought there was two issues. There's really only one. It just says she immediately notified Michael and terminated. So the only real issue is the immediate termination, as Tammy Lee just said. So this is the way you'd step through it in an IRAC, in your application section. Like I said, methodical, step-by-step, start at the beginning. In order for termination to be effective, where it relies on a process set out in the contract itself, it has to be strictly complied with. In Commonwealth and AMAN Aviation, now, before you see all that, what happened in Commonwealth and AMAN? What was the problem there?
That's where they hired a man to the aircraft wasn't ready in time, and yeah, so and it turned out not fair, but yeah. So I'm sorry, I'm not sure of all the facts.
No, that is the actual case that we are looking for, and I just want to hammer this home. That was the conduct in that case is quite extraordinary, and in fact so extraordinary that we revisit it in contract B. It's just a massive tangle of, I was going to say idiocy, but we have Commonwealth contracting for AMAN to perform aerial surveillance along our top north coast. They spent a huge amount of money fitting out airplanes, and it took longer, and so unfortunately they were in breach because they hadn't finished everything according to Commonwealth's liking by the time they were meant to be ready to do so. Now, the Commonwealth purports to terminate under this contractual provision allowing it to terminate. But it didn't follow the process. They had shown that there was this whole show cause process that had to be done. So where you terminate without good grounds to do so, and we will, in Contract B, we cover this in a lot of depth, and this is usually what my end of term exam question is on for Contract B. It has something to do with termination, usually. The Commonwealth didn't follow that process, so AMAN could accept that wrongful termination as a repudiation. Okay? Where a party has repudiated, that means that you yourself can say, okay, you don't want to perform this contract, you think you're getting out of it even though you have no legal reason to do so, fine. I will accept that as a repudiation, and what I will now do is I will terminate for your repudiation and I'll sue you for damages. And this is where we get into what I call the dance of termination. If one party purports to terminate and they don't have proper basis, the other party then can say, that's a repudiation, I'll accept that, I'll terminate and sue you for damages. And then normally the other party will say, no, you terminated wrongfully, that's a repudiation, and I'll terminate and sue you for damages. And you get all these cross claims. It's wonderful. There's a case called DTR Nominees and Motor Homes. It's hilarious.
There's another case like that too, isn't there, AJ? That I can't remember what it was, but there's another case I remember reading that quoted this case in saying that they were just, whoever it was just was always just going to cancel the contract anyway, and the whole clause in the middle was just basically a moot point. They weren't going to follow the process anyway. I just can't remember what case that was, but there is another one, I think, like this.
There's many. there are many. I like the scenarios in DTR nominees. I also like the scenario in foreign and white. There's another one. There's quite a few of them. So it costs the Commonwealth, this is our tax dollars hard at work, folks, $6.6 million. Okay. Here we have the agreement to be terminated by email on 24 hours notice. She immediately, she doesn't telephone him, informs Michael and purports to terminate at that time. So she hasn't terminated effectively per the contract requirements. So it'll be wrongful. Allowing her to accept that as a repudiation, she can elect to terminate and she can sue Michael for damage. He can sue her for damages. Okay? I don't think there's too much difficulty with that. Can she rely on the exclusion clause? Libby would not be liable for any damage caused to the house as a result of electrical faults. All of this party happened and it overloaded the electrical system, causing the fire, burning the house down. He wants her to pay his excess. Okay? Some of the ways around exclusion clauses. Now, some of these we've piped up and had a little look at last week in terms of, looking at, if the contract hasn't been signed, so the term's not included, or if there hasn't been sufficient notice given. None of those problems are here because the exclusion is right smack bang in the contract itself, isn't it? So it's squarely within the Lestrange and Gorka kind of rule. So what are some other ways around an exclusion clause? What are the two main ways? This one I'll just put in brackets and I'll leave you to explore my video on that. The main two ways that we need to look at are the contra proferentum rule, and yes, it's EM, and I didn't pick it up in the study guide. It's spelled UM. Please don't spell it UM. It's contra proferentum. Okay. And the other one is the four corners or the deviation cases. Okay. But before we even get to those, I think there's a nice little argument about whether or not the exclusion clause would even apply. If we have a look at it, the exclusion clause says Libby's not to be liable for any damage to the house as a result of electrical faults. Result of electrical faults. All right. What's happened here?
They've overloaded it. So is an overload a fault? Did it cause a fault? I'm not sure.
Exactly. These are all the questions I would want you to be struggling with. As good lawyers, we need to spot every opportunity for our client that we can. Attention to detail, attention to detail, attention to detail. Find points, look for them. Before you even get to the issue of contra proferentum, you need to work out whether the exclusion clause actually bites. Even if it did apply, does it actually bite on this factual circumstance that's occurred? Well, if the fire was due to a fault, the exclusion clause may bite. If not, the exclusion clause may not apply. We know that multiple devices caused an overload and then a fire. That obviously might have been due to a faulty electrical system which should have had circuit breakers. That I'm just trying to anticipate what the other side would argue there. But if the cause of the fire was not an electrical fault, just an overloaded system beyond normal tolerances, the exclusion clause may not apply. All right, if it does apply, we need to get around it. We need to get around the exclusion clause in here. We need to look at contra. Okay. And so, who can very briefly tell me what contra proferentum means?
Yeah, so basically the clause will be read against the person who's going to profit from, or who's going to benefit from that interpretation. Nice.
Yes. One slight addition I would pop in there. And it relies on the notion of ambiguity again. Ambiguities in an exclusion clause can be resolved by reading and construing the terms strictly against the proferens. The proferens is the person that puts the exclusion into the contract and then purports to rely on the exclusion. Okay. Alrighty. There's a nice little case here that I think would help us out. Did anybody spot it? And
is it the dinosaur on fire?
Just dinosaur on fire.
Was that, did I just read that in a stupor, or is there an actual case example in the textbook about a dinosaur on fire or something?
I think you're thinking of the little graphic that's from the TNT and May and Baker case where the truck caught fire.
No, I'm thinking in the textbook there was some a case example about a dinosaur on fire. Never mind.
Post it on, I'm intrigued to know now. Post it on Moodle.
Yeah, there is one.
Post it on Moodle for me. Post it on Moodle. The case that I am thinking of here, and I'm unsure, I don't think it's in Wilmot, but it is in Graw, so don't kick yourself if you didn't find this one. So here we had Alex Kay being a car hire company that had an insurance policy, and the insurance policy exempted the insurer to pay out if there was a breach of any breach of contract, agreement or obligation. And what happened was Alex Kay hired a car to a naughty thief. The thief nicked off with the car. Alex Kay claimed against the insurance. The insurer said, "No, we're not going to pay you out. We're going to rely on the exclusion clause because there's been a breach of contract." Who breached the contract? The contract was breached by the naughty third party. Well, guess what? Our exclusion clause says any breach of contract. So you're gone. We're not paying. Obviously, litigation ensued, and the insurer was liable. Why is that? Very, very clear instance of contra proferentum rule. Very, very clear. Scholl very nicely stepped through the requirements of contra proferentum. So in that case, there could be three interpretations of the exemption clause. It could exclude liability for breaches by Alex Kay, only Alex Kay. It could exclude for breaches by third parties, or it just could exclude liability for any breaches at all. And they said that first option was the strictest option, and that's the way they were going to construe the clause. So the exemption only covered breaches, covered the insurer, so that the insurer could deny liability if the breach of contract, agreement or obligation was by Alex Kay. Okay. So here I think that we have a similar argument. The exclusion clause was inserted by Libby. It excludes any damage caused to the house as a result of electrical faults. This could be faults caused by Libby, third parties, anyone. Do you see my argument here? Who caused the electrical fault? A paid entertainer. Third party. They were only on the premises because Libby let them on there. But similarly, in Alex K, the only reason why the third party had the car was because they let him have the third party have the car. So I'm lining it up there with that case. Okay, and then I think you could make those nice little arguments of the four corners rule, like you have very ably said to me, the TNT, May and Baker, all of those kinds of, let's see if I can, there we go. So the four corners rule, can anyone explain the four corners rule to me? Just a real brief summary.
Something about it only applies to conduct between the parties that is when conduct that is directly related to the point of the contract. So things that might be between the parties and whatever, but if it's not directly related to the performing of the contract, then it's not in it.
Yes. Yeah. It's another way of reading down an exclusion clause, isn't it? So what it basically says is, yes, you can put an exclusion clause in your contract, but if you do, it will only exclude liability for the range of conduct that is contemplated by and authorised by the four corners of that contract. If the conduct that is purportedly excluded, or liability for the conduct is excluded, if that conduct's so outrageous and unpermitted, not authorised, that it would never have actually fit into the four corners of the contract, then the exclusion clause is not going to work, okay, to exempt liability for that conduct. Okay, so what I've said is I've just given you a bit of a discussion there about how the deviation cases kind of morphed into the four corners rule. And I would prefer you to go from this discussion rather than the discussion that's in your study guide, okay? I think the discussion in your study guide is just a little incomplete. We have this four corners rule. And what I'm saying is that the conduct in her having the party was so outside the authorised permitted use of the premises that any exemption just doesn't bite because it's outside the terms of the contract. It's so outrageous, unpermitted, unauthorised. Do you know what I mean? Nowhere was she authorised to conduct large parties. It was the party that caused all the devices to be plugged in and fire. It was unthinkable. It was within the contemplation of the parties that an extremely valuable house would have been allowed as the venue for a party. So the exclusion clause should have no application to acts done that are never authorised nor permitted by the contract. Okay? Does that seem reasonable? Anyone have problems with that? Okay, so summing up, I think probably Libby would be liable for the plaint. In relation to the wheelie bin and the mail being dumped in there, I think there's a number of nice arguments you could make. I don't think the outcome there is a certainty either way. Could go Libby's way, could go his way. I think you've got a few cracking good arguments there anyway. In relation to termination, I think everyone conceded that it's probably not effective. And in relation to payment of the excess, I think you've got a decent argument that the exclusion clause would not apply. It would either be read down, according to Alex Kay, or it just would not apply at all under the Four Corners rule. Happy? I will put all of these notes online, as I always do. I've blown your minds. Yay! That's what tutorials are all about, folks. Okay, well, if you don't have any further questions, I'm going to run off to my contract beep beeps. Go and have a nice night, nice glass of wine. I'll see you next week. Bye.